Yeah, let's do it. Good evening, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk, the most fact-driven, unbiased true crime channel. I want to apologize. We start a little late. Sometimes things come up in the practice of law, and I just spent the last hour and 15 minutes on a phone call. So I apologize for that, but we are here. Thank you all for joining us here on our Tuesday night live. Immediately after this, we will do our Patreon live. So if you're not a Patreon member, now is your time to do so, and you can call in. That's kind of one of the unique things we have about the Patreon show is not only is it our Patreon show, but they get to call in and ask questions and just have a conversation. So tonight is also the night where we take your questions, and we'll try to do that. And we certainly don't beg for them, but I do tell you the super chats do highlight your question. So let's get started. Quickly, for those of you who do not know me or this is your first time joining us live, my name is Scott Reich. I'm a practicing criminal defense attorney. And so when we talk about true crime, I've been living it for the last 26 years. Brief time as a prosecutor in the United States Marine Corps, as a judge advocate attorney there, as well as being a defense attorney, and then a defense attorney in private practice. So, like I said, if there's a case, I've handled it, literally from the most minor things to the most serious, where they literally want to, put your client in prison for the rest of their life, or even one time, they were thinking about killing my client. So that didn't happen, so we succeeded. But anyway, that's what we do. So when I give you an analysis as it relates to a case, we'd like to stick to the facts. If you want to speculate about a lot of stuff, there's lots of other channels out there that come up with some crazy ideas. We try to stick to the facts and, keep it there. I'll give you the best analysis I have, best opinion I have based upon the facts that I have, and that may change if new information comes to light. So that's where we have it. Like I said, appreciate everybody watching. And, obviously, what's the word I'm looking for? And behind the camera here, we have Frank, the hardest working man in show business. And rapidly approaching the hardest working woman in show business is Julie, who, for a lot of you that joined in, she went down and sat through the Barry Morphy preliminary hearing, and she's going back. It was next week, right? Mm-hmm. Next Monday and Tuesday, she will be down in Salida as well. The Barry Morphy hearing, and I got a little bit of flack. I'm not gonna lie. Oh, you're just a criminal defense attorney. This and that. But I thought it was interesting the fact that Julie, who sometimes you got to tell people where you sit before you tell them where you stand, she was kind of going into it thinking, he probably had something to do with it. And she came out of there thinking, and correct me if I'm wrong, but you said at this point, I don't think there's enough at this point. So it's, we'll see. Barry Morphy has got some very good attorneys. They're aggressive. They are going to do everything that they can legally and ethically to represent their client, Barry Morphy. And I know that they want him to go home. And, more than likely their goal is they'd like to win that thing at the preliminary hearing. And, it's a very low standard. We've talked about this, but for those of you who may be not familiar with it, preliminary hearing is a very low standard of proof on a case. It's simply, is there enough that a reasonable person believes that someone may have committed a crime, that a crime was committed and this person may have had something to do with it. Very low standard. Not the standard at trial, which is proof beyond a reasonable doubt, which is the highest form of proof known in the law, not only here in the United States, but anywhere in the world. And there, proof beyond a reasonable doubt, and some of the language changes, but a quick nutshell version of it is that it is not a vague, imaginary, or a speculative doubt, but a doubt that would cause reasonable people to pause in matters of great importance, right? And what's of greater importance than somebody's liberty? So we'll see. Like I said, we'll give old Barry Morphy the presumption of innocence. I think the hearing is also a proof evident presumption great. And what that means is that if the proof is evident and the presumption's great that, this person had something to do with it and not looking good that he's going to prevail at trial, so to speak, the judge can find the proof is not evident and the presumption is not great, and then the court can set a bond. If the court does find that proof is evident, presumption great, Barry Morphy will be held without a bond. Right now, he's currently held without a bond, but this is their opportunity to do so. Like I said, I've seen the notes. I've seen not only Julie's notes, she took copious notes while she was down there. And, I've looked at other people that were down there as well. And like I said, maybe I'm just, I try not to be, I'll try to look at it as objectively as possible. But from what I've seen, please tell me you have more than doors opening and closing. You're going to need something else to put them over the although low standard of proof to make it happen. Who knows? I could probably tell you I've seen, and I've only had one case where it was thrown out in its entirety at a preliminary hearing, and it was one of those cases where you're just it was a simple case. I mean, think about this. It was a guy is a prisoner at a jail, and they find a shank in a mattress. Well, it's in an open squad bay, and there's holes in the mattress. I mean, unless you inspect the mattress and go and feel for it, how would you ever know it was there, right? And I asked the simple question of the officer that found it. What evidence do you have other than my client was sleeping on that mattress? What evidence do you have that he knew that the shank was in there? And the officer responded, none. And, everybody kind of looks around like, now what? And the judge, who'd been on the bench for 30 years, I'm going to throw the case out. First time I've ever done that. It doesn't happen that often. But then just recently, this is like a couple of months ago, we go to hearing on a first-degree murder case, and the judge doesn't bind it over on first-degree murder. I was like, what? Like, not finding first-degree murder? Thank you, judge. Just made my day. So maybe judges are getting a little more bold these days, or maybe we just got lucky with some good facts. But we'll have to wait and see. Let's see. Let's look at some of these questions here. Chelsea Morgan. Yes, we do, Mary. We are talking about, okay. They can't prove that she's dead. With some of the stuff they said, it's like she ran away. That's the old, I guess, Gone Girl defense. That was the Photos Doulos defense until he met his demise back there in Connecticut. But, we've seen it here in Colorado, particularly the Patrick Frazee, who was convicted of killing Kelsey Barrett. There wasn't a body in that particular case, but they also had some physical evidence along with a co-conspirator / accessory, an accessory after the fact, which was the nurse, Crystal Lee Kenny, that had something for, Patrick Frazee, even though she had a wife and 2 kids, or a husband and 2 kids, excuse me, and she drove out here and basically helped dispose of the remains. So that certainly helps, but as of right now, in this particular case, there is nothing to show what happened to Suzanne Morphy. I mean, you can say we presume her dead, and, let's be honest, she probably is, unless she went to Great Lakes to not take any money with her, to not communicate with her children, which seems not what a mother would do. So I think common sense would probably dictate that something bad has happened to her. But then it comes down to the law, and that is, what can the prosecution prove beyond a reasonable doubt? That's ultimately what's going to happen here. Jason Smith, I don't think the prosecution has the nuts up their sleeve. You'll have to wait and see. Yeah, I think it's going to be interesting also in the Barry Morphy matter is the mere fact that the 130, I think I've 125, 130, 150 pages, I've heard it, that they basically put their entire investigation in the affidavit for the arrest warrant. That's just lazy. We were talking about it, I think late last week. The guy in California, the surfer, and I apologize for not remembering his name, the guy that left his house, went to Mexico, and his children died as a result of having a spear fishing arrow, placed into their chest. And, that affidavit was 3 pages long, rather simple. This is what happened. This is the person that did it. This is why they're being charged with first-degree murder. Bottom line, it's that simple. And if you have to take 152 pages, man, I'm just telling you, it's like, okay, you got 152 pages, because maybe a couple of those pages has something to do with my client, in this case, not my client, but Barry Morphy. I'll take that any day of the week, and say, let's go, because it's simple. When you have a case, and as a trial attorney, they teach you and you learn over time. If you can't say what your case is about in one sentence or less, you probably haven't refined it. You haven't figured it out yet. Ladies and gentlemen, this is a simple case. It's a simple case about my client being wrongfully accused. He did not kill his wife, right? Bottom line, it's that simple. He didn't do it. Wasn't there. Didn't happen. Not responsible. Just like the prosecution, they have to be able to get up and say the defendant is guilty of first-degree murder. This is what he did. This is how we're going to show it, that it was him, not someone who looked like him, not someone using his identity. It wasn't somebody else, but it was him. And they did it on this day, and this is the instrumentality that they used, and this is how we know that this person is now deceased, right? Obviously, it's usually not a case, but when you have a missing body, it's very difficult to prove. Now, it's not impossible, but most DAs want a body. They do. And in this particular case, it came out that Suzanne Morphy was engaged in an extramarital affair. Okay, so what? It doesn't prove, and it certainly doesn't mean that she deserves to be killed. Let's face it. It sounds like the Suzanne Morphy, Barry Morphy matter was a marriage of convenience. Maybe they were even staying together for the children. Who knows? It doesn't sound like either one of them were happy, and things happen in life. It is what it is. And so, but what that shows is, what I've mentioned all along, everybody usually has a secret or some sort of double life going on out there. And it just shows, well, gee, if she had one boyfriend, maybe there's someone else that we don't know about. Maybe there's somebody that she upset. It just raises the possibility of there's something else going on that basically everyone doesn't know about. So that's what it goes to. It doesn't mean she's a good person, she's a bad person, right? Court is not about whether somebody is a good person or a bad person. I've represented really good people that have been accused and convicted of doing terrible things. Doesn't mean they're necessarily a bad person, but they're guilty of committing an act. And that's what courts are for. It's like I said, it's not a popularity contest. It's not a situation where you go around and say, I'm a good person. I couldn't have done it. I cannot tell you how many times, over the years, somebody says, I have been accused of hitting my girlfriend, right? Domestic violence. And the clients will come in and say, you know what? I didn't do this. Okay, well, tell me why you didn't do this. Well, let me just tell you, I'm a good person. And I've had lots of girlfriends in the past, and they have never accused me of hitting them. Therefore, I must be innocent. Okay, time out. That's not the way it works. You said you didn't do it. So explain to me why I didn't do it. Like A, you never did it. B, it was in self-defense if you had to, do something. But I don't really care if you're a good person. The good person, the good guy at letters, that's for sentencing. Let's talk about a defense. And over the years, I'm telling you, lots of clients, that's what they say. I couldn't do this. I'm a good guy. I'm a good woman. And therefore, it couldn't be true. These are all just lies. It's a travesty of a mockery of a sham. And how could they do this? How do I get my good name and reputation back? Well, I guess I tried to explain it. And hopefully this makes sense, and hopefully it's interesting to you all. But it's like your life. Remember those old reels of film? Everything's digital now. It doesn't really matter. But remember when you were growing up, they had like the reels of film, like the Super 6 or Super 8 film, I think is what it was called. And you could lay it out. And they used to be able to like splice it, right? When they used to edit films, they would lay it all out and they would splice different parts of the film together. That's kind of like what a criminal case is really about, okay? You take your life, that reel of film, and you lay it out and you say, you've had all this good life, and then we're going to break it down to this 15 minutes in your life that maybe is not your best moment, and we're going to like splice that out, right? We're going to splice out that 15 minutes out of your entire life and say, this 15 minutes is the only thing that we're concerned about. And did what is alleged happen or not? That's it, right? And then you have to bring in relevant information to prove the case, right? Think about it. Just go back to our example. Let's say, for example, it was a domestic violence situation. Somebody's saying, one party's saying the other side grabbed them, caused them pain, right? A simple assault. Grabbed them by the arm. They were having an argument. Somebody was walking away. Somebody else grabbed them by the arm, and the other person said, ouch. They have committed a simple misdemeanor battery at that point. Third-degree assault, right? There's only a couple of things you can say. A, it didn't happen. Wasn't me if it did happen. Or if I did it, it was in self-defense. That's it, right? So when you go to court, you can't go into court and, the prosecution is going to say to the complaining witness, the victim, and say, what happened on this particular date? Well, we were at home. We were having an argument. What were you arguing about? Oh, money, or the dinner was too hot, too cold. Who doesn't really matter, right? And what happened next? Well, I was going to leave. He said, don't leave. I was going to talk to him. What happened next? He grabbed me, and it hurt. It caused me pain. And I got scared. And what did I do? I then called the police. And what happened then? The police came up. What happened? The person who grabbed the arm, whether it's male or female, then was arrested by the police because he admitted that he grabbed the arm, right? Or he said, I don't know, I don't want to talk. But she's saying, you grabbed an arm, that's enough. Somebody's going to jail, right? The defense doesn't get up and say, isn't it true that you had an extramarital affair, 4 years ago? Not relevant. Isn't it true you have a speeding ticket? Not relevant, right? Only thing that matters is you take that whole life, those 15 minutes. What's relevant evidence? Evidence that goes to prove or disprove an element of the offense, right? You don't get to bring in the whole kitchen sink, so to speak. It's, what are the elements for third-degree assault? Think about it, the simple assault. That the defendant, on or about the date and place charged, knowingly or recklessly caused bodily injury. What's bodily injury? Pain. That's it. So if it doesn't go to prove that or disprove it, like it didn't happen, not true, you're making this up, you hated me, that kind of thing, it simply is not relevant. Yes, you can go into motive to fabricate, but generally it's going to say, it didn't happen. And it's a swearing contest. The complaining witness says, you grabbed me. The other person said, I didn't grab you. Guess what? A jury decides who is telling the truth. Happens all the time. These two people, the defendant, the complaining witness, they can both be very good people, or they could both be complete piles of horse dung. But it doesn't matter. The only job of the jury is to decide what happened. Did the complaining witness get grabbed by the arm? Did she feel pain? Did the other person do it knowingly or recklessly? What's knowingly? You're aware of your conduct, practically certain to cause the result. Not that you necessarily intended to cause them pain, but that you grabbed their arm and they felt pain. That's it. So, that's a trial, a simple trial. It's the same thing with a homicide trial in Barry Morphy's case. A lot of this stuff, the salacious stuff, is going to come in at the preliminary hearing. The rules of evidence are relaxed. But at trial, that may have not come in at all. But the defense, and they're doing what the defense is trying to do, and that is to try and get them to make their client look sympathetic. How do they look sympathetic? Oh my gosh, Suzanne Morphy was having an affair with her old boyfriend from high school, and they were love mates, but he's got 4 kids, I think it was, back in Michigan. And, my first thought when that came out was like, ooh, that's interesting. Ooh, maybe an alternate suspect. Well, guess what? He'd been eliminated as an alternate suspect. He could prove that he was apparently building a dock, I think with one of his children. He had receipts from I think it was Menards, was the store that he had gone to. He had receipts for that. Cell phone records had his phone pinging in Michigan at the time that Suzanne Morphy was to go away. So think about that. What relevance is that at trial? It really is not relevant. What element does it go to prove or disprove regarding this? I mean, maybe the slightest relevance I'm trying to think could be, well, Judge, she ran away. But if you're going to run away, unless you've got a secret stash of money somewhere where there's no indication that that's the case, where would she go? Doesn't make sense. So, although a lot of stuff comes in, so everybody needs to not panic. All right, everybody should not panic that, oh my gosh, Barry Morphy is going to get away with it. Okay, it is young. This case is young in the game. Hopefully, the prosecutor in this particular case, has a little more going on than what they've shown at the preliminary hearing, and that's just not me. That's even Julie, who sat there and watched the whole thing. But the other thing is the DA that's handling this case, she was in the paper recently as well. And apparently her office is having a bit of a dispute. Yeah, she's not coming in on Mondays, the DA's office. And let's see, here we go. Let me find this. Yeah. This is in Fremont County, which is part of the county. So you have Chaffee County or Chaffee County, depending on the part of Colorado you're from. And you have Fremont County, which fall under the guise of the district attorney in this case. And Linda Stanley is the DA there. And so there was some news that came out last week, I guess it was, where one of the judges likes to basically hold a docket 5 days a week. And a docket, for those who've never been to court, or, I'm sure you all probably have a pretty good idea, but, and this is one of my pet peeves when it comes to going to court and a docket, is that you have 80 cases that'll all be set, or 50 cases that'll all be set at 8:30 in the morning. Some judges in the world of WebEx have actually started to stagger this because they can. And of all the ironic thing, they had to save on the bandwidth space. So they've been staggering these cases. But some courts and many courts are back in person. So you show up. And like the old days, a year and a half ago, you would show up on a Monday morning. It's a docket day. They've got 60 cases set. 25 in custodies. You've got all the attorneys there. You got the public defenders waiting there, the DAs. You're trying to get everything done, maybe some last minute negotiation, setting the thing for trial. Who knows? Guilty pleas, whatever. Most inefficient thing in the world. But most courthouses try to break it up where either A, they have 1 or 2 days for a docket day. Monday or Tuesday, they do trials Wednesdays through Friday, or maybe Monday and then a Friday they do a lighter docket, but they do motions hearings in other cases that haven't yet gone to trial. And so they have that time to do, trials in between. Or if there's no trial that week, everybody gets an office day, right? And if anyone's ever had to run around, or you know how it is if you're on the road, it's nice to be in the office. I used to get antsy. Okay, this is showing you how much things have changed. If I was always in court until COVID hit, and if I had more than about a day and a half or two in the office, I would get like, oh my God, I got to go. Because I could get so much done by literally walking through the courthouse. You see a DA saying, hey, I need to talk to you about this case. Hey, let's talk about that case. Oh, you're here? You're here all day? Okay, I'm not leaving until we resolve this case. That kind of thing. But now with COVID, last year and a half, I've gotten used to actually coming to the office. It's kind of nice. Jump on the big monitor in the courtroom, have the client show up to do court. You don't have to drive around. I mean, it was wonderful. I would literally put 30,000 miles a year on my car driving from courthouse to, some days I wouldn't even make it to the office till late in the afternoon. So being in the office is a good thing. So this DA, Linda Stanley, is like, hey, my DAs need some time. And Judge, if you're not going to give us a break, we're not going to show up on Mondays. Well, Monday's usually kind of the busy docket day, but Linda Stanley and she's basically directed her deputy district attorneys not to show up in this judge's courtroom. It's Judge Robach. And, we'll see how this is going to shake out. It's going to be a battle of the will as it relates to the court, who obviously can't conduct stuff. And a lot of this came about because defense attorneys were saying, hey, we're here to have a sentencing, but we can't go forward because the district attorney's not here. Now, some judges will go forward. The DA's in the back talking about it. If it's a routine case, they can handle it. But usually you want your district attorney there. They're the ones that prosecuted the case. They're the ones that are making their statements as it relates to Victims' Rights Act. What is the will? What does the victim want for sentencing? Why is this case different than all the others that we sentence, the same way? And why, we deviating from this sentence one way or the other? So this Linda Stanley, she seems to be very, and I can tell you, I have not had an interaction with her, at least not one that I can recall. I have done cases in, I think, just about every county here in the state of Colorado over the years, but I haven't had any interaction with her. Frankly, I've never heard anything good or bad about her. But it sounds like she's taking a stand trying to protect her deputies and giving them some court time. Now, in all candor, though, we're talking about, unless the judge is making you sit in the courtroom from 8 to 5 in case something comes up on the docket, it seems a little harsh. Part of me is kind of like, oh, you don't have time to be in the office? Oh my God, welcome to my world, right? You think you got a quick court appearance and you show up and you got 80 cases on the docket, and your case is going to get, instead of 8:30, you can call it 11:30. You've wasted your entire morning. You maybe go get the file for the afternoon because you thought you'd be back. You had all this work you were going to get done scheduled. Guess what? When do busy trial attorneys do their work? Evenings and weekends. That's when you get the stuff done because you're working the rest of the time. You're meeting with new clients. You're meeting with existing clients. You're wrapping stuff up. When do you work? Saturdays and Sundays in the evenings. This past weekend, I was in the office both Saturday and Sunday. It's just what you do. It's also kind of nice because you get more done in 4 hours on a Saturday or Sunday than you do all week sometimes because there's no interruptions. Good point here, Barbara. There is the alleged $70,000 missing dollars from the safe that they were trying to open up. I'm not sure. We didn't hear much information about that. Julie was, I think, a little disappointed. Yeah, there was no information. I think it just came out that they did the search warrant. They searched the safe, or he let him into the safe, and he said, oh my gosh, there's $70,000 missing. Okay. How do you prove that there was even $70,000 in there? But maybe that's kind of the defense for her. Oh my gosh, she must have taken the $70,000 and ran away. She didn't tell anybody. Her life was so miserable. She didn't want to be with, her daughters, that there's been no evidence that she didn't get along with them in any way. And here you are, she ran off on $70,000. Now, can you live decently in some places on $70,000? Sure. But are you going to live a lifetime? She was, late 40s, early 50s, I think, Suzanne Morphy was. So, she's got a couple of good years ahead of her, even though there was talk of this cancer treatment, all that kind of good stuff. $70,000 isn't going to get you that much. So it's, like I said, I think the prosecution in the Barry Morphy matter has to get more. We'll have to wait and see. Kat leaves a comment here. I left my abuser 35 years ago. It can be very hard to get away when they threaten your life and the lives of your children. What I found in my case is once I got away, he cried, poor, pitiful me. Listen, there are no reports, at least anything that I've seen, that says, okay, somebody corrected me, Mary Rose, she was 49. Okay. It sounds like Suzanne Morphy at least expressed concern to her friend that she was concerned about her safety, that she was concerned about her physical harm. But from what I've seen, I don't think there was anything documented where there was actual physical abuse or anything that's come out thus far. Not saying it won't, but that we'll have to wait and see. But in relationships, if there is abuse, there is manipulation going on, a manipulative type relationship. That stuff goes on all the time. I'm not saying it's right, but it goes on. Let's not be naive to say, oh my gosh, everybody has a perfect marriage and everything's wonderful, and oh my gosh, how could this happen? There's allegations that Suzanne Morphy was concerned that Barry Morphy was having an affair. Nothing's come out as to that, although I think we got some, we like to keep it to facts, but, the locals usually know like all the good places to eat. It sounds like Barry, he thought pretty highly of himself. I think he kind of went to the gym and the spray booth or the tanning salon quite a bit, and, likes to flex his muscles, I'm sure, trying to get the women to look at him. So who knows? But as far as we know, nobody's come forward just yet, but we also don't have that affidavit. So hopefully we can take a look at that. All right, let's take a quick look at some of these questions here. Let's see. Is it Meredith? Barry's lawyers allow hugs. I'm assuming that's referring to their hugging, right? They were hugging him or something, or they're talking about the daughters were allowed to give him a hug. Well, if it's for Barry giving his daughters a hug, that's not on the attorneys. That's the sheriff's department. I can tell you I've had many a client that's been in custody and they have family members there, and you have to kind of, particularly through a trial, you have to wait and see. And if your client's behaving, normally the sheriff will, let them hug, quickly for a quick embrace. Some deputies are like, nope, those are the rules. I'm not going to allow it. Others are like, hey, I've seen it. This guy's not an issue. It's not a big deal. You can have a quick hug. The sheriff's going to watch him. They're going to be strip searched when they get back. So it's not like they're going to plant a handcuff key in there. But, from someone like me, I'm not a hugger. All right. Now, I've had lots of female associates over the years, and they have oftentimes complained that their clients wanted to give them hugs. And we've joked about it. And, it's just like sometimes I'm like, really? And I've had this from female associates over the years that have said, oh my gosh, we were done, and the client was so happy they gave me a hug. And I'm thinking to myself, gee, that's funny. My clients don't hug me. Maybe they can tell I'm not a hugger. But it's also a little weird. You're not going to hug your, I guess, maybe after maybe a trial win, they slap you on the back kind of thing, but we're not huggers. And I know it's made, female associates uncomfortable when people wanted to give hugs when they're like, I'm not, like, why are you giving me a hug? So I'm not a hugger. I'm not, the most at trial, maybe we'll pat them on their shoulder and say, yeah, he's a great guy, but we're not going to embrace. And even if it was a female client, all the more reason not to embrace. Why would you want to do anything that's going to look weird and inappropriate at any time? Ooh, great question here. Let's take a quick detour here. Scott, any tips for a first-time jury duty call-up? Yes, I love this question. Okay. If you have never been on jury duty, this could be one of the greatest experiences of your life. Okay. And I have never made it to jury duty. I know judges who have made it onto juries. I wish I could be on a jury. One of our associates, she had jury duty just the other day. She spent the whole day there waiting to get called up, and then they sent them home. But jury duty could be the most exciting thing you can do in your life. I've never talked to a juror who said that they had a bad experience on jury duty. Maybe they said, oh, it was a little inconvenient, whatever. But I think most people truly like it. It's an awesome responsibility. And other than voting, right? You always hear, oh, you got to vote. It's your right as a citizen. This is your civic duty and obligation. This is so exciting because the jury system does not work unless people show up, right? Think about all the countries in the world where you don't get a jury to decide what happened. You get some bureaucrat, some judge appointed by some government official that's going to probably make their decision up before they get out and hear anything, and that's it. I mean, it shows you, the founding fathers, the fact that they trusted their own citizens to do it, but it doesn't work unless people show up. And so when you show up for jury duty, there's going to be all the standard general qualifications. Are you a resident? Are you 18 years of old? Do you understand the English language, right? Because although a defendant or a witness can have a translator, a juror cannot. And the biggest thing is say, hey, listen, I'm going to give the defendant the presumption of innocence. I'm not going to give either the defense or the prosecution a head start. Everybody's entitled to start off equally, right? That's it. Don't appear too eager. Don't appear like you don't want to be there. I've had some people over the years that have been too eager to want to be on a jury and makes people nervous. Okay. Yeah. It's, I'm not thrilled to be here. There's lots of other things that I could do. I got a lot of projects going on at work, but I understand this is my civic duty. And if I'm selected, I will be a good juror. I will do my best. That is the perfect juror, right? Reserve judgment until the case is over, listen to the evidence, and then follow the court's instructions. Those are the general qualifications to be a good juror. You can do that. And then you have people that want to get off the jury so bad, they'll say anything. You can always tell the guy that's not, or the woman that's not going to be there. I just want to let you know, I have a business trip planned in 3 weeks. And I just want to let you know that, Judge. Okay, well, this trial is probably going to go for 1 to 3 days. And if we're here 3 weeks from now, something's gone terribly wrong. Okay, well, I just want to let you know. And then they come up with an excuse on everything. It's like popcorn. Boom, 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 right? And then people start figuring out if somebody gets excused, oh, that's how I get out of here, right? I've literally had people get up and say, yeah, I can't be fair and impartial. I'm a racist. I've had people say that to get out of jury duty. Yeah, I'm a racist. I can't do it. I just can't do it. I've seen that defendant over there. Look at his beady little eyes. I just can tell he's guilty. Soon as I heard that charge read, I knew he was guilty. I just can't do it. Seriously. And these people just embarrass themselves. And you're thinking, oh my God, I hope that neither you nor anyone in your family ever, ever, ever needs a fair and impartial jury. So Hann-Spree, Hann Spree. That's my tip for jury duty. Just go in, listen to the evidence, and listen. Be fair and impartial. If the prosecution proves their case, then it is your solemn oath and obligation to find the defendant guilty. If, however, the prosecution fails to prove their case to even just one element of the charge, it is your solemn oath and obligation to find the defendant not guilty. These are standard instructions that you would receive. So just do that. Follow the instructions. Don't appear too eager. Just tell them it's your civic duty, and you'll be more than happy to do it. Scott, what typical jury instructions? Oh, the jury instructions that are read. The court reads, the general introductory statements. If one is selected, the judge will say, okay, after everybody's selected and they sort out and you got your 12 jurors, the judge will kind of lay out the process. But then you have the jury instructions that says, all right, all the evidence now is concluded. And some of the instructions go for pages. The presumption of innocence is pretty long. The charges, the allegations, quick synopsis of the allegations. The defendant has entered a plea of not guilty. The burden of proof is always on the prosecution to prove each and every element of the offense. The defendant has an absolute right to not to testify, and you cannot draw any negative inference from that whatsoever. You are the sole judge of credibility. You can believe some, part of, or none of a witness's testimony. It's completely up to the jury. And these are what they call the stock jury instructions. You tailor instructions based upon the charges and any evidentiary issues that came in, but those are the stock instructions. And it says, if the government meets their burden of proof, you need to say guilty. If they fail to do it, it's you have an oath and obligation to say not guilty. These are read out aloud to the jury, and so everybody hears it. Some judges give the jury a copy of it, each and every one. Some judges say, no, here's just one for the foreperson. If they're selected, they get one copy. But those are the standard jury instructions. It's the standard stuff that we talk about here all the time. Presumption of innocence. The defendant doesn't have to do anything. The burden always remains with the prosecution. The jurors are the ultimate judges of credibility. And the ultimate decision maker, the ultimate fact finder of whether the prosecution has proven their case beyond a reasonable doubt. So hope that answers your question. I think I already bumped off the person's name, but I'll see if I can't find it again. Let's see here. Let's see. Mad Matt, if I'm paying you however much you're charging me, you're going to get a hug whether you like it or not from me. It's part of our agreement. Laugh out loud. Yeah, okay. That's funny. Let's see. Red Bunny here. Why would he not be? He murdered someone, yet you don't like that. Okay, this is somebody else talking. Sometimes it's hard on these chats because people have their own little chats going amongst themselves sometimes. Silly question. How many suits do you have? Ooh, interesting, Karen. Well, today I'm not in a suit. I just have a sport coat on because I didn't have any court. And over the COVID years, I've kind of got used to not wearing a suit because I used to wear a suit every day. But if I were to look in my closet and count them, I would say I probably have 15 to 20 suits, I think. Yeah.
How many ties?
How many ties? Oh, probably. And I clean these out, but I probably got a good 40. But it's funny, You always like, there's always, how you have that favorite piece of clothing, like, like that suit, like they just got it right. Or that tie, just like, oh, I like that tie. You wear it more often than the others. The plan is, I'm going to have all these suits. And of course, they're blue, they're gray. They got the pencil pin stripe. They all look the same. You probably say, oh my gosh, God, how do you, all your suits look the same? Exactly. They do. Nothing crazy. Never going to go out of style. What was it a couple of years ago? Oh my God. It was the worst fashion thing ever. And correct me if I'm wrong, maybe a show of hands here. Who thought it was the worst style ever? Where guys would wear suits where it looked like, if you wore that to school as a kid growing up, they were like, oh, you got high waters, the flood waters are coming. And they wore the boots with the suit, super skinny tight, like, this far above the ankle. Worst style ever. And I remember seeing attorneys, and it was young attorneys, and I was just like, dude, you need to get yourself a new tailor. Like, that's going to look so dated, so fast. You're just going to, why would any tailor say that's what I want? And does anybody wear that stuff anymore? No. Completely out of style. Okay. One place you're not going to go in and, change the fashion world is the courtroom. It's still very conservative dress. Very conservative dress. It's, blue suits, gray suits, white shirts, blue shirts, and ties. That's it. You don't you don't get crazy with it. I mean, it's one, as a trial attorney, you're trying to do whatever you can to convince the jury to listen to you. And if you're distracting them with your poor clothing choices, that isn't going to help, okay? Because I'm telling you, it's distracting to me. If you go to court on a docket day and you show up and some attorney is in there and they've got like tennis shoes on with a suit, like, it's distracting to me, okay? And, some of us have like, oh my gosh, like if your attorney shows up with, tennis shoes on and a suit, like run, or like sandals. They show up with sandals and like wool socks. Like, oh my God, don't hire that guy. It's distracting. It makes you question their judgment. You just don't do it. Attorneys need to go to court, look like an attorney. That's just my humble opinion. Me personally, like I said, you go to blue suit. I think I've got one gray suit, and the only reason I got that was my haberdasher, my suit guy, said, "Hey, I know you ordered this suit, but for some reason when they made it, they gave you this color. Like, do you want it?" I'm like, "Sure." And everyone's like, "Wow, it's so out of your box." It was like this gray suit. But yeah, other than that, you keep it simple. And I ordered a suit once. Oh my gosh. And they come with a little swath of, not swath, what's the word I'm looking for? Swatch of material, and like, okay, here's what the suit's going to look like. And I'm like, oh yeah, that'll be good. And I got the suit and it was this gray. And for some reason I thought the pinstripe would look good. It was like skinny little pencil thing, but it was super wide. And I looked like something out of a gangster movie. And I think I've worn that suit maybe 3 times. And the other rule of thumb is you always, you should get your suits made. I'm telling you, a good custom made suit is not that much more expensive than going to buy something off the rack. Just a little hint pointer there. And I've got my people, and I'm telling you, if you ever had a custom made shirt, okay, you can go buy something off the rack, but you got a skinny neck and bigger, shoulders. It never fits right, stuff like that. I'm telling you, for the few extra bucks you pay to get your custom shirts made, you never go back. A couple years ago, for a Christmas gift, gave all the associates, X number of shirts through the guy that makes our shirts. And everybody's hooked. They're all like, oh my God, I love these things. I'm never going back to off the shelf. That's just like it is with a suit as well. Unless, of course, right now, I'm not going to lie, if COVID has shrunk a couple of your suits, they fit wonderfully. They just kind of hang perfectly. No Crocs ever. And I, with his groovy crime pays suits. Yeah. Alexa, see, somebody remembers that. This is just a sport coat. Got this from Homer Reed, which is a nice men's shop down in town. It's Stanford. But my suits, if you've ever had a suit made or you've seen it, they can put your name in it. And I said, I don't put my name in it. I have in my suit. Maybe I'll show it to you the other day. But you open it up and it says, "Crime pays." I'm sure that'll probably offend somebody. Because crime, kids, doesn't pay. Being the criminal does not pay for sure. But, when you have to get people out of custody, it pays sometimes. Not as much as some other areas of practice of law. But you'd be surprised when people's liberty was at stake. They usually find money. Thank God for parents, grandparents. Absolutely. Let's see here. What about jean suits? Yeah, no, not a suit that you're going to court in. And I get it. You can always, casual, but that's the beautiful thing about sport coat, right? You can always put a sport coat on and it's great. I mean, you can have a pair of pants on, right? Throw in a pair of Gucci loafers. You look like you're set. And you're good to go. You're a little too overdressed. Take the sport coat, take the tie off, but you can still do it casual. Lace up, tie up shoes, but I'm telling you, the most comfortable pair of shoes, worth every penny. And I think I wasn't actually going to get these, but years ago, the lovely Miss Kristen forced me to get them because she's a big fan of Gucci shoes. And I said, I don't need a pair of Gucci shoes. And then I got them on. And oh my God, the most comfortable pair of shoes ever. Let's see. Yeah, Gucci, call me. Just kidding. Chelsea wants to know, Scott, when are you going to introduce us to the lovely Miss Kristen? Miss Kristen doesn't like to be in front of the camera. She's very shy. And I don't, don't really care what people think about me. And some people, they don't get to that. Were you scared the other day, Julie, when you were in front of the camera?
I was always afraid of maybe some hate comments. But
Yeah, Julie, I mean, you're worried. Oh my gosh, what if they don't like me? What if they, I'm telling you. And one thing you learn when you start a channel or something like this, the slightest thing that you do wrong, say wrong, piece of lint on your coat, you name it, somebody's going to point it out. Mispronounce something, God, we've been through that, haven't we? Jeez. Yeah, so that's why she doesn't want to do it. I think she thinks the people will be not so nice to her, although I think I'll be here to protect you. Need a red velvet, white patches and plaid. What is that, like a smoking jacket or something, And you have to get a suit at the Salvation Army store. You fall in the mud on your way to court and you have to get a suit. I guess so. Could happen. Yeah. But if you got a couple more at home, you better do it. What's the latest on Lorivalo? Lorivalo. I mean, geez, what do we have to say about Lorivalo? As far as we know, she's still in the state hospital being restored to competency. She has a new attorney that has been appointed. He actually is an experienced criminal defense attorney. And yet Mark Means continues to file frivolous motions and motions to compel and sanctions for this and sanctions for that because he doesn't get it. If I was the judge, and most judges, and I've seen a lot of judges, they're like, listen, I'm not going to handle a discovery dispute unless and until you all both absolutely say you can't work it out, right? The items have either been produced, i.e. made a copy of, or in some form, digital or hard copy, or items have been allowed to be inspected. That's it. If the defense thinks the prosecution needs to turn something over and the prosecution says, I don't have it, how can I give it to you? And they say, the defense says, well, it's within your care, custody, and control because these police officers report to you, then maybe you have a dispute. But 99.9% of the time, you should be able to work it out amongst yourselves. If not, then you go to the judge. And it just drives me nuts. Whiny little motions practice stuff. I think it goes back, and I've said it along, and I don't want to sound like I hate civil attorneys because we do some civil work here in my practice. But the reality of it is you work it about amongst yourselves. It's called being professional. Only civil attorneys run to the court all the time to say, I didn't get this paper and he didn't turn it in and I want attorney's fees. Okay, you're not going to get attorney's fees in a criminal case. It's usually pretty well settled law that you're not going to collect money from the prosecution. They don't do that. In the civil world, the judge can sanction the attorney, sanction the parties. Not there. The remedy is you don't get to use it in the court case if you don't turn it over. But you have to show prejudice. And when your client, like Lorivalo, is still in the state hospital being restored to competency and all the proceedings are stayed as it relates to your client, how can you possibly show prejudice? So when Mark Means filed that frivolous motion the other day to dismiss the indictment because what was the nonsense? Something wasn't turned over in time. Like the case, he said that they scheduled a court date knowing that she was not competent to proceed. Well, they probably would have scheduled the court date to have a court proceeding to state that she isn't competent and that nothing's going to happen. But yeah, he's trying to say that was outrageous conduct and the case should be dismissed. Are you serious? If anyone should be sanctioned, it should be Mark Means for filing that nonsense, okay? And people think, oh, you just pick on Mark Means. Oh, my God. Because has no clue what he's doing. What he's filing is crap. And I think once or twice when I agreed with what he did, I said so. But, when he just keeps shoveling, it's garbage in, garbage out. He keeps shoveling the garbage in. I got to explain it's garbage out. It's garbage. He needs to realize that. Okay, big super chat here, 1999. Amy Co 3167. I missed it. That's okay. Respect and love from Amy, Greenville, South Carolina. Sorry, I'm not sure what you missed, Amy. Maybe it was the show. I don't know, but you can always go back and watch it. That's good. So, so the new attorney for Lorivalo completely, he has what's the word I'm looking for? He has experience. He's handled very, very serious criminal cases. What did he file? He filed an entry of appearance and motion for discovery. Seems fair enough, letting everybody know I'm the attorney of record. Please include me in all things. Let me have a copy of the discovery. You would think that maybe Mark Means would want to coordinate with the new attorney who's got some experience as a criminal defense attorney before he files motions to compel, particularly when your client is there. So where's the prejudice, right? That's when sanctions are imposed against the prosecution, is when there's prejudice imposed. A mistrial, a dismissal as a sanction is a drastic remedy. And the court always has to tailor the least severe remedy available. We don't even have a trial date. She's not even back yet, for goodness sakes, from the hospital. We don't even know if she'll ever be restored. Although I'm kind of thinking somebody must have some clue that she's going to be restored. It's going to be a miracle. I can see it now. It's a miracle. She's been restored. And I think that's why the judge, I can't say for sure, but I think the judge looked at this and said, okay, they're going to go death on her, just like him. Clearly, Means does not have the qualifications to do a death penalty case. Let's get her counsel. Let's get him up to speed. So we'll see. I think, and maybe these two get along. Maybe they know each other. Maybe they've never met in their life. But I think there's going to be a situation where these two There's going to be, there's going to be some interesting dynamics, but somebody is going to prevail as lead counsel, and I think it needs to be the new attorney for sure. Mr. Archibald, I think is his name. So we shall see. Let's see here. Daniel Donovan question. Do you think that the tampering with a corpse charge against Barry would mean LE has found some physical evidence in one or more of the garbage bags or in the dump they went to? Would that mean law enforcement has found some physical evidence? Well, Daniel, I'm going to give you the typical lawyer answer, I guess. It just depends, right? We don't have the affidavit for the arrest warrant. It's been released. I totally disagree with the court's ruling, but hey, he's the judge. And, hopefully we'll get it here shortly after the preliminary hearing. The tampering with evidence, yes, if they believe, and I don't want to say that because I don't have the charges in front of me. I used to have a pile of stuff, but we cleaned up a little bit around here. The tampering with evidence can be lots of things. If they think that he was trying to do something, I'd have to look at the tampering evidence charge. So I'm not trying to be evasive, Daniel, but I think that we'll have to see. It could be where they were thinking that he, deleted a text message, deleted a chain of an email chain. That could be tampering with evidence where it tried to do something. So I guess my question is, we'll have to wait and see. I really don't think they have any physical evidence from any of these bags whatsoever. At least in the Photos Dulos case back there in Connecticut, they had blood found on the floor in the residence where Jennifer Dulos was last seen after dropping the kids off at school. She went back and they, believe that that's where it happened. Then they had some video of him dumping some bags off with the girlfriend. And, it was just, they had something to show that there was probably something amiss, some foul play, some criminal activity was afoot, so to speak. But here, I don't think they have any. Even the whole bike thing sounds a little weird. Maybe the weirdness of the bike being dumped down, or placed there, but no indication that the bike was ridden there. Marks, scrapes that somebody got off, that there was a struggle. Nothing is obviously weird. Maybe it looks like somebody was doing it. The question is, who did it? According to Barry Morphy, he was in Broomfield, Colorado, just a stone's throw away here from the CrimeTalk studios, preparing for the workday, even though he was apparently spending a whole lot of time in his hotel room, except when he went out to do these trash runs, and some took considerably longer than others. If I'm staying at a hotel, what is there? I think some of the notes that I saw said the trash that they were dumping looked like it was construction related, like planters and things like that. But I don't know. We don't have enough information. And this is going back to when Julie spoke with us last week about her stuff, is that it's like they would get to this point in the preliminary hearing and both the prosecution and the defense would stop short of that great moment. Like there's building up to something and there was nothing there. So we'll just have to wait and see. All right. Wow. Can you believe an hour has passed already? Couldn't you just do this for 3 hours every night?
That would be great.
I can hear Frank. He's loving it. He's like, oh yeah, let's do this 3 hours every night. This would be great. I could do it. I'm not sure how the lovely Miss Kristen would like it. Oh yeah, well, the lovely Miss Kristen would have to bring her sparkling rosé. Julie could bring her wine. Frank, I don't know what you drink, if anything. I'll just, I've had 3 Red Bulls today because I went into the 7-Eleven and got some Red Bulls, and it was 3 for $3 or buy 2 get 1 free. So I've had more Red Bull than I've had in a long time, and I love Red Bull. I drink 2 to 3 a day, but these are the big ones. Let's see here. You can only make your assessments as detailed as your notes. Thank you, Jen. Why would they do that, Scott? I'm sorry. What? I need to join Patreon. Yes, Chelsea, come join us. We're going to go to our Patreon here shortly. Wow, I can't believe it goes by so fast. And wow. Let's see here. Let me see if there's anything we can answer here before we go. I'm in on the Patreon. Thanks, Adam. Come on in. We're going to have a good time. Like I said, Patreon, you get to call in. Let's see here. Jen Love, bring your ice cream to the Patreon. All right. Wow, can't believe it went by so fast. So, we did this today in the video that we did today. Hopefully you got to watch it. And, and for Scott to hopefully be able to quit his job real soon, I say that jokingly. But, for Scott to quit his day job as an attorney, what would I do? I could do this like all day long, but I'm not sure people would like to sit until we talk about it all day long. But please support our sponsors that help us. It's not me that you guys are paying. It's the people on the other side of the camera that helps them out. So go to crimetalksearch.com, for background subscription search. And also, it's a weird time in the world today. And I think if anybody or recent world events have shown you, at the end of the day, you are on your own. Okay? No matter all the promises that the government can make you, you're on your own. You need to be able to do it. I've said this for years. If you got to take care of yourself. You need to be able to take care of yourself. And one way to do that is go do crimetalkprep.com. I'm telling you, think about it. I mean, I've been here in Colorado most of my life, other than I was in the military. Get a big snowstorm. People are stranded for 2-3 days. Nothing to get in or out. What are you going to do? People stock up. We saw this stuff, not long ago on toilet paper, right? Shortages. You got to take care of yourself. So support the people that support us. We appreciate it. All right. Thanks for watching. Have a wonderful evening, and we will see our Patreon members here shortly. You'll get that link sent to you, I do believe, and we will be ready to go in just a couple of minutes. Thanks for watching. We'll see you next time on Crime Talk.